What's going on, everybody? This is Lady Luck. All right. Happy Saturday. Hope everybody's doing well. Wanted to get in a couple recorded videos before I did my members only live stream tonight because that's what I'm doing. I want to talk about this new bill that is set to be signed by the governor of Illinois. It's the Parrot, aka Pritzker. I've been calling him that forever, and that's what I'm gonna keep calling. This is the same governor, if you recall, who pretty much wanted to stay out of anything going on with Lil SS over there in Dalton and Thornton when she was there wreaking havoc and had nothing to say. I guess because Lori Lightfoot and the FBI were doing things. Two different types of investigations at that. And somehow he, being the governor of Illinois, failed to intervene. Well, here we are again. And there is a Senate bill that has been passed but not signed. So typically, when a bill is passed through the state legislative board, it has to be signed by the executive figurehead, being the governor. Every branch of level of government we have, from federal to state to local, there remains the three separate but co-equal branches of power. And I know I've mentioned this several times, going over many lawsuits that I've been going over for 2 or 3 good years on various topics, as well as ensuring that, when it came to reporting on what was going on in Dalton and Thornton, that you guys understood the role of the trustees as the legislative board and the role of the mayor position as the executive branch. And here we have, now on a state level, you have the governor representing that executive branch, and then you have the state legislators, of course, that being the Senate and Congress members at the Illinois, for the Illinois State Legislative Board or representation. So they'll pass the bills, but the governor has to sign them in order for them to become effectuated. So there is a situation in Harvey that I came across, and I was also told about from a couple other content creators, where there was some property, I don't know, seized, or some squatters or something to that extent. I'm telling you, I'm not reporting on things in Harvey like that. I was, reporting on the issue with the alderwoman, Kobe Chapman, being arrested, and the excessive force that was used with that, and the argument that can be presented when they go to court about the excessive force. The U.S. Supreme Court has passed down a new ruling on what is defined as excessive force, which is in effect. See, these things have to be in effect, so that they can be applied against the new law or the new bill, if by chance you have to go to court. Right now, the Senate bill has not been signed by the governor. Just because it's passed does not mean it's in effect. There's a difference. So if the squatter, Mr. Hassan or whatever he is, maybe the property owner, if he was removed under this new bill, the new bill was not in effect at the time he was removed. So he could go to court, say, Your Honor, I did not get due process. I did not get a hearing. I don't know who removed him. It has to be an officer of the court, which would either be Cook County sheriffs or, a process server who is able to, execute an eviction, but they have to be an officer of the court. So otherwise, you set yourselves up for a lawsuit if you're not doing it the right way. And people get iffy when you say things like that, but get upset when things come down the pipeline and then they realize legally they've messed up. So this bill, as you all can see, and I'm on the Illinois General Assembly website. This is the bill status for Senate Bill 1563. And this is regarding the new squatters' rights bill, basically where they won't have to go through the legal process to have squatters removed if the owner can prove that they are the rightful owner of the property and that the property is being occupied um, by squatters, the sheriffs can come out or the police officers can come out and have the squatter removed immediately upon the property owner rightfully proving that they are the rightful owners of the property. That means you would need some documentation. Not you just saying that, because that's not going to be good enough. It shouldn't be anyway. And if that's how it works, simply by just saying I own this property, then what makes that more credible than the squatter who's staying there saying I own the property? This is why we have things done in the court of law, because it forces people to have to produce evidence and documentation. So you guys can see the status of this bill as of June 18, 25 is still sent to the governor. He hasn't signed it. When is he going to sign it? Who knows? But that is the last action for this bill. It passed, but it has not been signed by the governor. And each branch of power have to be involved when it comes to passing, on a state level, passing these bills. This is state statutes. This will become state law. And then there's a process called, typically seen as a stress test, right? So once the bill is passed, a lot of times, it's challenged in court with a lawsuit. You have some attorneys that say, well, the law itself is not debatable. How it's interpreted could be based on other case law. And then whether or not overall it's reasonable. Does it interfere with, constitutional law, like such as due process? If that be the case, then this new bill could be deemed unconstitutional. There may be parts of the bill where it has to be amended or it has to be, repealed altogether. Who knows? It has to kind of go through that stress test too. So even if the governor signs it, and let's say something happens and someone decides to, such as Mr. Hassan, he wants to file a lawsuit, go to court. You can say, well, at the time that I was removed from this property and this property was taken from me, I was the rightful owner of it. Here's the information or documentation. Or we were in the middle of proceedings. The city had not properly evicted me from, the property itself. And I would have been able to prove that I'm the rightful owner or had the right to occupy the property, especially if it's pending litigation. So you can't evict someone or remove someone from the property on a bill that is not in effect. That does not make it in effect because it passed. The governor must sign it in order for it to be effectuated. It's just like a court order that is drafted and sent to the judge to sign. In order for that new court order to be effectuated, it must be, 1, signed by the judge, and 2, filed with the clerk of court. Both things must be done in order for that court order to be effectuated. Otherwise, you cannot effectuate a law that has not been signed by the executive branch. No different on the federal level. Bills that pass must be signed by the president. It can pass through the Senate, through Congress. That's the legislative branch of government. But it must be signed off by the executive branch. That's how it works. And then it goes through that kind of a stress test, if you will, with the judicial branch of government. And this happens all the time. This is not the only bill that's ever been passed in United States history where it did not go through what is looked at as a stress test to see how viable the law is and how effective it is. If it seems to go against, federal law, because with state statutes, you have to be careful. It can't negate or go against, constitutional law or, basic constitutional rights and protections that, we all have here as U.S. citizens. It can't go against, federal laws. It certainly can't contradict the laws that exist. And what you see here is introduced as it amends the Code of Civil Procedures. This is what I'm reading. It amends the Code of Civil Procedure, provides that nothing in the eviction article may be construed to one, prohibit law enforcement officials from enforcing the offense of criminal trespass under the Criminal Code of 1963 or any other violation of the code, or two, to interfere with the ability of law enforcement officials to remove persons or property from the premises when there is a criminal trespass. So that's a totally separate concept. The squatters' rights is, yes, flawed. Now I'll say that. However, it is the fact that there's always been a level of due process in place. Some states, are just like Illinois, are trying to pass laws to kind of pull that back a little bit, because the legal process, as far as litigating an eviction through court, can take months to do. You can literally have someone occupying, property, and a homeowner or landowner is trying to evict someone, and it could take 6 months to a year even, before it gets to the point where it's in court. And then the court may, the judge might decide to give them extra time to figure out if, okay, well, maybe they can come up with the money to pay rent or something to that extent. And this is not just in the state of Illinois. It's just always a lengthy, very irritating process, aggravating to say the least, to have someone evicted. So when it comes to having this new bill like this, where you're saying, if the homeowner, the property owner, can prove on the spot in the presence of an officer of the court that this is their property, they're the rightful owner, and that these squatters should be removed, what this bill will do is circumvent that litigation process. But it has not been effectuated. The governor hasn't signed it. And you can't go to court and say, well, it had passed and, that new bill is in place allowing us to do that. No, was it in effect? Because then his attorney can make the argument, well, Your Honor, the bill was not in effect at the time on the date that the incident occurred where my client, was removed as a squatter. So, and I'm also going to go through a couple of articles that I came across showing that there's some history with this Mr. Hassan in the city of Harvey with the mayor and Lil Diva up there, honey. It's just some history with them. So, things like this it's a little touchy. And you always have to have to be careful, because what you don't want is to end up having action taken against you for doing something that should not be occurring. And you know premature actions are being done, and this bill has not been signed by the governor. So I wanted to pull this up. This is an article that I came across on Harvey World Herald. And this is where Lil Diva orders police to remove entire audience from chambers at city council meeting. This was back on last year, July 15th of 24. But I want to go down to let's see here. To where I saw information about Mr. Hassan. See, this is what's highlighted. Business owner, I'm not going to try to mess up his first name, Shahnawaz Hassan, owner of food manufacturer American Kitchen Delights on Dixie Highway, alleges the mayor and police chief had officers write frivolous traffic tickets to his employees in 2020. Hassan, who criticized the mayor last year during public comment, has three ongoing lawsuits against the city. So there's history between Mr. Hassan and the city of Harvey, especially with Lil Diva. That's history. And if you're talking about this was in 2024. I don't know what the status of those cases are, but I'm just showing the history of the back and forth between the two and the strife that the two have had with each other. And I mean, I'm not gonna put it past Lil Diva up there not to be retaliatory, because clearly he can be when he's willing to have people arrested for clapping, as if someone is supposed to get his permission to exercise free speech. No, they don't need your permission to do that. That's not how constitutional rights and protections work. You're not a I mean, you want to be a dictator, but that's not something you get to dictate or control. But this is just showing some history between these two. 3 lawsuits. So, and here's, I think, one of the, I don't know, I don't know if this case is still pending or not, but this is going back to 2019 here. I just found this on Justia. A docket of American Kitchen Delights Inc. etc. Ex al. versus City of Harvey et al. It's basically saying that there's multiple defendants and co-plaintiffs. So they have Chicago Express Towing LLC, Shanawaz Hassan, American Kitchen Delights Inc., and Wadi Isbai Isbai versus Keith Price, City of Harvey, Illinois Municipal Corporation, Derek Muhammad, and City of Harvey. This is going back to January 14th of 2019. This is went to federal court here. So this is a 2019 case. This is just more history that they have. He has with the City of Harvey and having to file lawsuits here. You got Keith Chicken Nugget listed up there, because of course he is. But I mean, when you have this type of history going, the last thing you want to do is agitate the situation because it looks retaliatory to have this man removed. I don't know if he was removed by an officer of the court. You need a license to do that. And if not, then that's a problem. And then, of course, on a bill that has not been signed by the governor. It's just, it's not worth it to, to put yourself in a situation where that can tremendously backfire. Here's a letter that I came across as well. This is from the Attorney General back on December 27, 23 on Kwame Raoul. This was a FOIA request. Mr. Dennis Both, American Kitchen Delights, Ms. Cheryl Anderson, the deputy city clerk, and he wrote the letter out to both parties. The binding opinion is issued by the Attorney General, and they have pursuant to the 5 ILCS 140/9.5 section F. For the reason discussed, this office concludes that the City of Harvey violated Section 3D of FOIA, and they recite the Illinois code by failing to comply with, deny in whole or in part, or otherwise appropriately respond to a FOIA request submitted by Mr. Shanawaz Hassan. So more history with Mr. Hassan and the City of Harvey. More bad history here. 3 lawsuits, one of them having multiple defendants listed. Now you have this FOIA request that was not answered, and then he turns around and gets, removed from. If he's a squatter, it's understandable to want squatters removed. However, whatever you do, let it be done in decency and in order. At least have the bill passed and signed by the governor. Both things need to occur in order for that bill to be effectuated. And I just literally refreshed that webpage, the Illinois General Assembly, with the bill status in real time. The last action sitting there is of June 18th, 25, where it went to the governor. It does not say that he signed it. And I've looked. And I was saying to myself, I hope he has signed it. But it doesn't look like he signed it. There are a lot of sponsors on this bill. It passed through, which is awesome. But that does not mean it is in effect. And it just, something simple like that. Just looking up this information and ensuring that things are done the right way, can prevent a lot of headaches in the future when it comes down to litigation matters, especially if he has other pending lawsuits against the city. You have here where the Attorney General had to basically find the City of Harvey in violation of the FOIA law. So he filed a request, submitted a FOIA request back on August 31st of 23, to seeking any and all kinds, any documents that identify amounts billed to the City of Harvey by the law firm Ansel Glink or Kathleen Conkley during the period January 1, 22 to date. The request meaning to date as of August 31st, 2023, or whenever the FOIA was submitted. Yeah, it looks like it was submitted on August 31, 23. So you're talking about over a year of billing information from a law firm to the city that he requested. The request also sought records identifying real property. Look at this. Real property to the city sought to acquire through the Cook County no cash bid program in 2023, as well as related correspondence resolutions requesting participation in the Cook County no cash bid program, including any third party requester affidavits, affidavits of intent, certifications regarding the no cash bid request, lists or schedules of properties to be acquired, and affidavits of occupancy. So it seems like he was requesting information for properties to see, perhaps to acquire a property or to buy a property. No cash bid. This is not something I'm familiar with up there. I don't live in Illinois, but the no cash bid program for Cook County, including the third party requester affidavits, affidavits of intent, certifications regarding the no cash bid request, list of schedules. So he basically wanted to know about the program and who had any intent on purchasing certain properties. So when you have a FOIA request dealing with, information on properties where the attorney general, who doesn't seem to really do a whole lot when it comes, depending on who's the mayor, the attorney general, though, sitting this binding opinion, finding that the city of Harvey violated the FOIA law, and he's specifically requesting information on what seems to be a no cash bid program to get property. And then he turns around and gets removed from property as a squatter. I mean, how do you think that's going to look in front of a judge? This is going to look and sound just convoluted and crazy in the court of law. And you best believe he's probably going to file another lawsuit. And if he has an open or pending lawsuit already in court regarding anything with him and some property or, eviction or him trying to become owner of property, it's going to be amended, and the whole issue of him being removed is going to be added onto it. And he'll be able to show, look, I have a history of trying to get properties, to acquire them, right, to get information on them. I mean, I've had 3 or 4 lawsuits. The attorney general has had to send an opinion saying that they've violated FOIA laws. Like, this is insanity. So this is what I mean by not doing things to agitate the situation and to do things in decency and in order, and to at least ensure that any bill or law you're acting upon is actually effectuated. It's in effect. Because if not, then you can't use laws that are not in effect to act upon, to cause some action upon someone. There's certain laws that no longer exist because they get outdated. I mean, that happens. You can't use an outdated law and say, well, it was passed once upon a time, so we're going to use that to put somebody out their house, and the law's not even effectuated anymore. It's no longer valid. If people are going to go to court and say they use some outdated law to have me evicted, like this law has not been effectuated, has not been signed by the governor. So now look, there's a bit of a mess here because of that. When it could have just, okay, we wait till the law becomes effectuated and then we act and go from there. But there's so much history with this. I'm not saying not to remove squatters. I'm saying that if you're going to do it right, and do it with laws that are in effect. And to understand a little bit of history and how this could be presented to a court, because this could be a little nasty, and it's just going to go back and forth, back and forth. And I think if he were a squatter and little diva up there who's known to retaliate and violate, constitutional rights, really wanted this man evicted from the property, wouldn't he not have done this already? I mean, what's to stop him if he has people arrested for clapping? What is to stop Lil Diva from having what he perceives to be a squatter removed from the property. And why didn't he do it himself? You know why? Because he's a lawyer and he knows that, well, the law is not effective yet. Because I would assume he would have already done it. He doesn't have a problem having someone arrested with excessive force. That's an older woman. He doesn't have a problem having people arrested for clapping. Why would he all of a sudden now he can't seem to get a squatter removed from some property? Lil Diva couldn't do that. Chris Clark himself couldn't do that. I mean, isn't he weaponizing law enforcement? Wouldn't he have already sent them out there to do this a long time ago? There has to be a level of logic in this too. It's no logic for anyone who might not even be an officer of the court to have anyone removed on a law that's not in effect. If he really wanted to retaliate, he would have done it. That's just my 2 cents on this. It just, I don't see why he would still allow this man to occupy, property as a squatter when he's done far worse and abused constitutional rights of others without impunity. I mean, he does it without even blinking. Why would he have a difficult time removing a squatter again? No one asks this question of themselves. It makes no sense. I would caution anyone going out doing his dirty work. Don't do it. Because if you go to court and get caught up, guess what? He's going to sit there and say, well, I wasn't there when that was happening. I had no idea what happened. I didn't do that. I was not the one out there making the call. Because, that's what cowards do. Ain't that right, Lil Diva? That's what they do. They circumvent and then they go around and they hide in a corner like a coward. And they don't take any responsibility or accountability for anything. They leave it on the person that they sent out there to go do it. Now, you want to go out there and do his bidding for him? Good luck to you. But to operate on a law that has not even been signed by the governor and put into effect, it's just a foolish thing to do. And I would leave it to an officer of the court to evict any squatter from any property. If you're not licensed or certified as an officer of the court, don't do it. But if you do, understand the consequences of your actions is what's going to happen behind it. Because it doesn't make sense. So the request was put in on October 10, 23. Public Access Bureau emailed the FOIA officer for the city a copy of the request for review and a letter asking whether the city had received and responded to Mr. Hassan's FOIA request. October 10, 23. Letter also requested that if the city had not yet responded, it do so and provide this office with a copy of its response. The city did not respond to the Public Access Bureau's October 10, 23 correspondence. On October 27, 23, the Public Access Bureau sent a letter via USPS to the Deputy City Clerk, Michelle Anderson, stating that this office had not received a response to its October 10, 23 letter, attaching a copy of that letter and requesting a response. This office also emailed a copy of that correspondence to the city's clerk's email address. The city did not respond to the Public Access Bureau's October 27, 23 letter. On November 16, 23, an assistant AAG in the Public Access Bureau called the city clerk's telephone number, but was unable to reach the city FOIA officer. This is how they're handling FOIA requests and being found in violation of FOIA. What's going on up there in the state of Illinois where you have multiple mayors not wanting to address FOIA? What is the deal? This is insanity. This is how they're handling a FOIA. You think they're going to handle a squatter's right bill correctly? Having an eviction done legally and lawfully the right way? When Lil Diva arrests people for clapping in 23, was he not the mayor? I think he was the mayor. That was what, 2 years ago? So you mean to tell me that they could not even adhere to a FOIA letter? And then Kwame Raoul is just a joke for so many reasons. But yet and still, these laws are in place. Little diva, you're not above them. You're not above reproach. And you went to law school. See, here's the thing. I know when a lawyer is lying, they're very slick tongued. They beat around the bush. They don't answer direct questions because, of course, not. And yet, and still, they have everybody else do their dirty work for them while they run off and say, I ain't got nothing to do with it. Okay. Yeah, if you're falling for that, and then you've just fallen for it, and I don't feel bad because this is insanity. This is how they're handling a FOIA request, people. They couldn't even get the city clerk on the phone. Lord. I laugh at this because it's just absolute buffoonery. Um, on December 1, 2023, this office extended the time for issuing a binding opinion by 30 days of business days, pursuant to Section 9.5F of FOIA. As of the date of the issuance of this binding opinion, this office has not received confirmation or any indication from the city or Mr. Both that the city has responded to the FOIA request at issue in this matter. And then they have the analysis here. They have the law cited. Um, just kind of going through what happens, in the event of denial. I'm not going to read the whole thing. So we'll go down to the findings and conclusions. After full examination and given due consideration to the information submitted, the Public Access Council's review and the applicable law, the Attorney General finds that 1, August 31, 23, Mr. Hassan, on behalf of American Kitchen Delight, submitted a FOIA request to the city of Harvey on October 2nd. And it was on the city's attempts to acquire real property via Cook County's no cash bid program. And I wanted to read this because I believe that it is imperative and related to the property that he has been removed from, I think. Although not, I don't see how that would legally stick right now, considering the fact that the bill has not been signed by the governor. So that could be, you know, properly challenged in court. It's a matter of the reality of the situation. Be properly challenged in court. So, and he has the right to challenge it in court. Should not be intimidated or threatened not to do it. He has the right to challenge it in court. So this is on August 31st. Tried to get information on the Cook County's no cash bid program. On October 2nd, Mr. Dennis Both, attorney for American Kitchen Delight, submitted the documents required to file a request for review with the public access counselor, alleging that the city had not responded to Mr. Hassan's FOIA request. Mr. Both's request for review was timely filed and otherwise complies with the requirements of Section 9.5A of FOIA. On October 10, 23, the Public Access Bureau forwarded a copy of the request for review to the city along with a letter asking whether the city had responded to Mr. Hassan's FOIA request. The city did not respond. Of course they didn't. It's just too much like right. God. Oh, too much like right. Too much like right. Like we're supposed to do something. Yeah, many laws says that you should do a lot of things the right way. Even when listen, there are a lot of laws I don't like and agree with, but they're there. I'm not a lawmaker, so they're there. Unless somebody calls the governor and says, "Hey, man, you need to sign this bill," it's not in effect until he signs it. Oh, sweet Jesus! You have to pull up that. Ah, God, please don't make me have to pull up the process on a bill becoming effectuated. But come on. Oh my God. Um, On October 27, 2023, the Public Access Bureau sent a second letter to the city's FOIA officer via both email and U.S. Postal mail, stating that the Public Access Bureau had not received any indication that the city had responded to Mr. Hassan's FOIA request. The city did not respond. On November 16, 23, the Public Access Bureau attempted unsuccessfully to reach the city's FOIA officer via telephone. Because they're not answering phones at work now. Okay. On December 1, 23, the Public Access Bureau extended the time in which to issue a binding opinion by 30 business days pursuant to Section 9.5F of FOIA. Therefore, the AG may properly issue a binding opinion with respect to that matter. As of the date of the issuance of this binding opinion, this office has received no information indicating that the city has responded to Mr. Hassan's August 31, 23 FOIA request, because they're ignoring the person that might be trying to do this the right way. But I mean, how the hell do you determine he's doing it the wrong way when you're not responding to FOIA requests where he's trying to get information on the county's no cash bid program regarding properties? Go figure. Like, this is so asinine. It makes no sense. Why not respond? And I don't know if they responded by now. This is going back to 23, but it's sad that it took the attorney general to send this letter. Dig into us and come and find us and see what you find. Oh, okay. Don't put that challenge out there. I don't think you can handle the response on that, little diva. You issue a challenge on something like that, and you don't know who might respond, and it might go over your head. This is insane. See, a lot of people aren't going to just believe what you say, because, you know, I know when a lawyer is lying like hell. This is insane. So, it is the opinion of the Attorney General that the city of Harvey has violated Section 3D of FOIA by failing within the statutory time for responding to Mr. Hassan's August 31, 23 FOIA request to provide copies of the requested records, or to deny the request in writing in whole or in part. So they didn't fulfill it, nor did they deny it. They just let it sit there and linger in the wind. Accordingly, the city is hereby directed to take immediate and appropriate action to comply with this opinion by providing Mr. Hassan with copies of all records section responsive to the August 31, 23 request, subject only to permissible redactions, if any, under Section 7 of FOIA. And then they have the state statute regarding that as amended by Public Acts 103-154, effective June 30th, 2023. And then, of course, they have some other acts that are with the actual number and effective dates. See, effective dates. Even for act or policy or bill. It being passed does not indicate it is effective. It has to be effectuated. If the city determines that any portion of the responsive records is exempt from disclosure under Section 7, it is directed to issue a written denial that fully complies with the requirements of Section 9A of FOIA. You can't just say, well, this is not a request that we can fulfill under this law. You have to show and prove how. When you chose to not respond at all, it would be kind of weird and awkward and just downright dirty to sit here and say, oh, no, this is not something we can give out based on this law. It's just insane. All right. So this opinion should be considered a final decision of administrative agency for the purposes of administrative review under the administrative review law. Aggrieved party may obtain judicial review of the decision by filing a complaint for administrative review with the Circuit Court of Cook County or Sangamon County within 35 days of the date of this decision, naming the Attorney General of Illinois and Mr. Dennis both as defendants. So yeah, it was like, if you want to file a complaint, go ahead. Make sure we're listed as defendants. Then we'll go from there. I don't know if this was ever adhered to and fulfilled or what, but I just wanted to read this to show history between Mr. Hassan and the city of Harvey, and the fact that he tried to get FOIA information on this program regarding properties and has filed 3 lawsuits so far in this, whole ordeal. The last thing you want to do is sit here and, take an action like this for him to be removed as a squatter. Even if he is a squatter, let the law, you gotta follow the law, because this is what happens when you don't. It gets real messy in court. And then, you get disappointed when a judge tells you something and says, all right, well, you guys chose not to do that, so you got to pay this fine. Or here's what the judgment shall be that I'm going to grant him, because now he's had to sue you. And where is Little Diva going to be at when that happens again? Yeah, because he's not going to, He's going to ensure he's not named as a defendant. Oh man. Ooh, child. This is a mess. So I want to put it back on this. Oh man. And I'm gonna make sure. Pull up facts on, you know, Senate bills being in effect. Because I want to make sure I'm correct on this. I sign my check. The overview of how a bill is passed and effectuated. And I want to make sure that it's still, unless something is changed, the governor still has to sign the bill in order for it to be effectuated. That still has to happen. So, and I'm just gonna look at, there's a lot of bills that was passed. Then the question would be, were they signed? Okay, so here's some information on the process here to a bill becoming effectuated. And I just wanted to be clear and sure on the facts that I present here to make sure it's accurate. I'm only going to read, you guys can go on, this is the Illinois Physical Therapy Association. I don't know why this came up, but either way, how a bill becomes law in Illinois. And of course, I pulled up how bills, become law in the state of Illinois, because most states do it the same way, but it might be some nuances that might vary state to state. So I wanted to make sure I pulled it up correctly for the state of Illinois. So, seeing that the bill has already passed through the chambers, through General Assembly, we're going to start here at the bottom. As you all can see, I wish I can zoom in on this a little bit more. No, it won't let me zoom in. There we go. I hope you guys can see that. All right. So once the bill has passed the General Assembly, the legislature must send the bill to the governor within 30 days. So this was done on June 18th. Today is June 28th. All right. Keep that in mind. Once the bill reaches the governor, I'll make sure I'm able to read it all. All right. Once the bill reaches the governor's desk, three things can happen. One, the governor can choose to do nothing. If no action is taken within 60 days after the bill reaches the governor, it automatically becomes law. After 60 days, it's only been 10, and not even 10 good business days. So I'm assuming the 60 days would be calendar days. So let's say it's been 10 calendar days. Let's give it the benefit of the doubt that this means 60 calendar days, not business days. It's only been 10. It landed on his desk June 18th. It's June 28th, as of the day of me recording this video. So after 60 days, it automatically becomes law. 2, the governor can sign the bill into law exactly as it is. When a bill becomes law, by whatever means, it is called a public act and is assigned a public act number. The governor can veto the bill one of two ways. A total veto means the governor vetoes the entire bill. An amendatory veto is when the governor makes specific recommendations for changes to the bill that, if made, he/she will sign the bill into law. This is also called a veto message. In the case of a veto, either type, the General Assembly can do nothing and the bill is dead. Override the veto by a 3/5 vote in both chambers. In the case of an amendatory veto, the legislature may agree with recommendations made by governor by a simple majority vote, and the bill becomes law. So, generally speaking, sessions begin in January and at the end of May. Veto session is held towards the blank of the calendar year. In? Why is the word missing? There's a word missing there. Yeah, I don't know what's going on. They need to update this article. So veto session is held towards, and I want to say, assume this means end of the calendar year, but it could be beginning. I don't know. Usually in late October, November, December. So it could be end of the calendar year. So these are the three things that happen once the bill hits the governor's desk. So even if he doesn't sign it, he still has to wait 60 days. That means the laws it's not effective until either the 60 days pass or he signs it exactly as is. What if it needs changes? Well, if it needs changes, it goes through that veto message or it goes through a complete veto altogether. If he wants to a total veto, if he wants to veto the entire bill, let's say he reads it and he gets the attorney general to go over it, and then it discovers that it might infringe upon due process, right? So it could be in part or in whole amended or changed or vetoed because now you're talking about it interfering with, a constitutional law, constitutional protection. And state law cannot do that. It would then be deemed unconstitutional. So there's a series of steps that must occur. It passing through the House is not what makes it valid or effective. It's got to at least pass 60 days once it hits the governor. It has to be signed exactly as is, or it can be signed exactly as is, or it could be vetoed. And if it gets vetoed, it will not be in effect until whichever veto process occurs, until that is completed. If it's vetoed and General Assembly, if it's a total veto, and let's say General Assembly, it says here, they do nothing, the bill is dead. So now you've had someone removed on a bill that could be total vetoed and then end up being dead. And then what? This is why it does not pay to act irrational and move without using good judgment and wisdom and having the full knowledge of the steps that we should be taking before such action occurs. Because uprooting people's lives, even if they are squatters, it's still hard. I mean, we can't, we want to make sure things are done the right way. But, let's have a little empathy in this and do things according to the law now. Because right now, he's still owed due process. It still has to go through the court. This is why Lil Diva didn't do anything. Because he knows that this is in place. He knows that this is how bills are passed. He went to law school. And he's not going to sit here and take the hit if the judge actually, let's say Mr. Hassan files a lawsuit, and the judge is like, yeah, there's a good argument here. He has a case. He's not going to want to take the hit if Mr. Hassan is granted any judgment. The city will have to pay whatever that judgment is. And for what? Because Lil Diva can't seem to, accept the fact that everybody's just not going to agree with his nonsense. Retaliating is not the way to go, but he keeps doing it. But he damn sure didn't get his ass out there and go and try to remove a squatter either, because he knows better. And this is not the trouble he wants, where he ends up in court. Last time he was sitting in an administrative hearing, he had perjured himself after saying that he was going by another grown man's house just to see if the lights were on. Yeah, it's insane, I know, but he did that. Oh, what a clown he is. All right. This is all I got, y'all. Thank you so much for tuning in. I hope you guys, listen, and all that get some understanding. Reading is fundamental. That's what we do here in the Lady Luck Club. I just, I wanted to be able to share the facts with you guys and to show you all there's a certain way to do things. And there's a lot of contention, going on with these two parties, with the city of Harvey and Mr. Hassan. There's a history of contention, lawsuits, and FOIA requests not being addressed until the AG had to send a letter. Who knows what's happened with that? I'm not going to dive too deep into it to find out, because at this point I think it's irrelevant, because it does not override the fact that a bill is sitting on a governor's desk. It's only been there for 10 days and it is not effective. And that's what the judge is going to care about. Under what law did you enact or, operate under to remove a squatter or what you're deeming to be a squatter? And are they true squatters? Eh, Don't go out doing his bidding when he doesn't do it himself because he's a punk. He's a punk. He's a punk. All right, y'all. Thank you so much for tuning in. Hit the like button and subscribe if you're enjoying what we're doing here in the Lady Luck Club. I'm going to speak my mind and say things as it is. And I'm also going to pull up information and facts and, laws because that's how it goes. I just, I wouldn't operate outside of that because it's just too much of a headache if you get caught up. But if you want to get caught up, good luck to you. Either way, you guys tune in. I will be going live to the members only tonight and having a good time and getting a good laugh in. And I hope you guys consider become members so you can come hang out with us. We're going to be going over a very funny video that I want to finish up with the LLC gang. And I thank you all so much for the love and support here in the LLC. And until the next one, Lady Luck Club out. Deuces.